All right. Any other changes or guidelines,
No
challenges?
other additions or corrections. I do have scoring challenges, Your Honor.
Okay, go ahead.
With regard to PRB 5, that was scored at 10 for 3 or 4 misdemeanor convictions. When I review defendant's record, I'm counting at least 8 prior misdemeanor convictions, which would bring that to 20.
All right, Mr. Gilbert, your response?
Well, Your Honor, I would go to the Department of Corrections because I did go and check after the prosecutor brought that up and they verified that their number was correct. So I was.
Yeah, well, let's see. I'm looking at the adult history. So no security doesn't count. Plate doesn't count. No security doesn't count. MIP doesn't count. No ops doesn't count. Attempted larceny, that's misdemeanor 1, offense 6 of 23. No ops doesn't count. Number 8 of 23, possession of marijuana, that'd be misdemeanor 2.
Your Honor, I would withdraw that
Okay.
challenge. And then I do have challenges to OB1, aggravated use of a weapon.
Okay.
The offense narrative in this and the police report indicate that defendant possessed a glass bottle. One of the witnesses informed authorities that he threatened to slit the victim's throat. The victim later sort of seemed reluctant to say, but did later state that he did threaten to cut her with the bottle. Did ultimately throw the bottle, hitting her leg, causing a bruise. There is People v. Lang, 25 Mishap 247, that states a glass mug could be counted as a weapon, cutting or stabbing weapon for scoring OB1. So I would argue that OB1 with those facts should be scored at 15 points, Your Honor.
Mr. Gilbert, your response?
Well, I would go back to, and granted, I wasn't prepared for the challenges, and Mr. McClellan did say he was going to challenge some of the OBs just prior to court. He did tell me that. However, I don't believe it meets the requirements, and I agree with the way it is scored, that by it being tossed at her or thrown at her was not a weapon displayed or implied for purposes. And also for the victim was touched by any other type of weapon. I don't believe the actual touching took place to score either 5 or 10 points.
Well, I'm not going to score it for, I think, a slightly different reason. I think it's a McGraw issue. The sentencing offense is possessing methamphetamine in the car. The small amount of methamphetamine that was found during the traffic stop. There's no indication that the possession of methamphetamine occurred, that he used or possessed a weapon during the sentencing offense. So under People v. McGraw, I don't think I can score that conduct. So OBs 1 and 2 will remain at 0 points. Any other scoring challenges from the people?
Your Honor, the only other one then would be OB12, contemporaneous felonious acts. People would argue that the facts just stated with regard to the glass bottle would be a felonious assault that occurred contemporaneously with the sentencing offense, which would bring OB12 to 5 points.
Okay, Mr. Gilbert?
And I guess I would argue that that he pled to the possession and that no other felonious activity would have taken place pursuant to our plea.
All right, well, under OB12, it's contemporaneous felonious criminal acts. And here it's alleged that there was one contemporaneous felony act involving a crime against a person by throwing the glass bottle at a person during a threatening and assaultive situation that did occur within 24 hours of the sentencing offense. It's in unchallenged portions of the pre-sentence report. So I find by preponderance of the evidence that there is sufficient basis to score that. OB12 will be scored at 5 points. Any other scoring challenges from people?
No, Your Honor.
Okay, that would bring the total OBs from 0 to 5 points. This is on class D.
There's no change.
Okay, so that'd be it'd still be a level 1. So the range would still be 5 to 23. Okay. All right. So Mr. Gilbert, anything you want to say on behalf of your client?
Your Honor, I think the young man that's standing before you has actually understood that what has brought him here. And him and I have talked prior to today's court via telephone, and then again before today's court. And with his sentencing, he understands that the road that he's on is causing him to be in jail now almost nonstop. Prior, while this case was going on, he's been in the Alpena County Jail. And also, and as he went through the things, he was going through his prior record with me, and he's going drug related. I was on meth here. I think he's acknowledging that that path is causing him to have these felonies and all this jail time. While he's been incarcerated, he has been doing counseling, and he has gotten certificates of completion, numerous ones that it appears that he's generally trying to grab a hold and change his life around. I mean, his record is by no means stellar, and he understands that. And I asked him what he's planning on doing once he gets out. And he does seem to have a plan that he's going to go work for family members and try to get his life in order and continue on with a form of sobriety and addressing his drug addictions. And I hope that's accurate. He seems genuine in his resolve to do that. And I would ask the court to follow the recommendation. Thank you.
Do you know when has he been sentenced in the Alpena matters?
Yes, he has.
What date was that on July 21?
Yes, Your
Just a week ago?
Yes,
What sentence did you get?
I got a year, Your Honor.
Okay.
Your Honor,
Yeah.
our understanding is that was 2 years probation. With, I believe 1 year jail.
Okay, yes. All right, Mr. McFarish, you don't have to tell me anything today, but is there any statement you want to make?
I'd just like to apologize to the courts and everybody that cares about me. I could do a lot better than this, and I will.
Okay, thank you. Mr. McLennan, any recommendations from the people?
Yes, Your Honor. The plea agreement in this case calls for a county cap. I think under the circumstances, that's a huge benefit to the defendant here. During this case, he did abscond on bond and a bench warrant was issued. This case obviously involves substance abuse issues. He failed the Alpena drug court program in 2016. He has a fairly extensive criminal history. The PSI indicates 6 felonies, 22 misdemeanors. Many of those are traffic offenses, and he's only 30 years old. Just noted was just sentenced to Alpena for another substance abuse case. And given those facts and circumstances, Your Honor, I think the county cap would be appropriate. Thank you.
Thank you. Well, Mr. McFarish, you do have not a good history as outlined by the prosecutor and in the pre-sentence report, and it sounds like you're fully aware of that. You've previously had the Department of Corrections boot camp program. It sounds like you've had treatment court, so people have tried a lot of different things, which is why then this is a case that, it sounds like there was a lot going on that led to the police contact, but you're not convicted of those things. What you're convicted of, and what I'm sentencing you for today, is possessing a small amount of drugs in a car during a traffic stop. That usually doesn't result in a straddle cell guidance, right? But because of your record, if you jaywalk, you're probably in danger of going to prison, right? Your guidelines are just going to be high no matter what you do. That's not unfair, right? We ought to treat a first-time offender differently than a repeat offender. That seems to make sense. But we do have to also keep in mind what we're sentencing Mr. McFarish for, and we are sentencing him for possessing a small amount of drugs in the car during a traffic stop. I think the recommendation from the Department of Corrections is within the advisory guidelines. It's within the sentencing agreement of the cap, and it seems proportionate to the circumstances of the offense and the offender. So I'm going to order that you serve 8 months in jail. I'll give you credit for it. Looks like by my count, you're entitled to another 21 days credit. So 172 days credit. That's the sentence of the court. If you wish to appeal, you can file an application to the Court of Appeals. If you want a lawyer, you have to ask me within 6 months. We're going to hand you a piece of paper explaining those appeal rights and ask you to sign a copy for us. The other one is for you to fill out if you wish to take an appeal. Good luck to you, Mr. McFarish.
Thank you, Your Honor.
Oh, yeah, and I'm sorry, there's also $68 in state costs, $130 in crime victims assessment, and $350 in court costs. Thank you.
That hearing had a little bit of everything. People v. Mr. Wegerish was one of those cases where the past comes back hard, and in this instance, it shaped just about everything in the sentencing conversation. Judge Aaron J. Gauthier presided. Sharp as ever, balancing legal technicalities with a human understanding of how addiction weaves its way through the justice system. The scoring debate kicked off with a challenge from the prosecutor, who spotted a discrepancy in prior record variable 5. He argued it should be scored at 20 instead of 10 based on at least 8 prior misdemeanor convictions. Defense counsel Mr. Gilbert initially pushed back, citing Department of Corrections verification, but after some clarification from the judge on what actually counts and what doesn't, he withdrew the challenge. Then came the contested offense variables. The prosecutor made a strong argument that the defendant throwing a glass bottle during a prior incident should count toward aggravated use of a weapon backed by case law. Gilbert countered that the weapon wasn't displayed or implied. As required, ultimately, Judge Gauthier sided with neither. Instead, he ruled that under People v. McGraw, those facts weren't directly tied to the sentencing offense. So OB1 and OB2 stayed at 0, but it wasn't a total win for the defense. The judge agreed to score OB12 contemporaneous felonious acts based on that same glass bottle incident, reasoning that it was a separate, uncharged felonious assault that occurred within 24 hours of the sentencing offense. 5 points were added, but the total still kept Mr. Wegerish's guideline range at 5 to 23 months. With scoring settled, Mr. Gilbert painted a picture of a man at a turning point acknowledging his drug-fueled past and actively trying to change. He noted that Wegerish had earned several completion certificates while incarcerated and had solid post-release plans involving family employment and sobriety goals. The defendant himself spoke briefly but sincerely. "I can do a lot better than this, and I will." Then the prosecution stepped up with a sober reminder. Wegerish had absconded while on bond, failed out of drug court back in 2016, and racked up 6 felonies and 22 misdemeanors, all by the age of 30. The people had agreed to a county jail cap, which the judge described as a huge benefit given the facts. Judge Gauthier, in a clear and composed explanation, said it plainly, sometimes your record catches up with you. The possession charge at issue here, meth in a car during a traffic stop, was relatively minor. But because of Wegerish's criminal history, even small infractions push his guidelines higher. If you jaywalk, the judge said, you're probably in danger of going to prison. The final sentence, 8 months in county jail with 172 days credit, plus the usual financial assessments. Respectful, proportionate, and measured is what you'd expect from this courtroom. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.